Welcome back to our channel, where we delve into the deeper questions that shape our society. Today, let's explore a fascinating legal case that challenges our understanding of personal freedom, safety, and the balance of power between citizens and law enforcement. Imagine this. You're hanging out on a busy street corner with friends, casually chatting, when suddenly a police officer approaches you. What would you think? This scenario is not just a thought experiment. It's the real-life story of John Terry and a veteran detective named Martin McFadden in Cleveland. McFadden, with nearly 40 years of experience, observed Terry and his friends behaving suspiciously. To him, their casual demeanor looked like a rehearsal for a robbery. But was it really? As McFadden approached, he felt he had enough reason to stop and frisk Terry, ultimately discovering a loaded revolver. This brings us to a pivotal question. What constitutes reasonable suspicion? Is it merely a hunch, or must it be grounded in observable behavior? The case, Terry v. Ohio, made its way to the U.S. Supreme Court, where the justices faced a critical dilemma. The Fourth Amendment protects us from unreasonable searches and seizures, but can police act on a mere suspicion? The Supreme Court's ruling, yes, under certain conditions. The court said that what McFadden did counted as both a stop, seizing Terry's freedom to walk away, and a search, frisking him for weapons. But even though those actions are covered by the Fourth Amendment, they don't always need the same high standard of proof as an arrest. Why? Because the court decided there's a balance. On one side, people have the right not to be hassled by police for no reason. On the other side, officers have a duty to protect themselves and others from danger. If an officer sees unusual behavior that makes them reasonably believe a crime might be happening and that the person might be armed, the officer can stop the person briefly and do a limited pat-down for weapons. Notice the limits here. It has to be based on specific observations, not just a vague feeling. And the frisk can only check for weapons. It's not a free pass to search pockets for evidence of anything else. In Terry's case, the court said McFadden acted reasonably. He had specific reasons to suspect a robbery was being planned, and the pat-down was confined to making sure nobody pulled a gun. But let's pause here. Does the idea of reasonable suspicion create a slippery slope? Could it lead to profiling, where individuals are stopped based on their appearance or behavior rather than concrete evidence? Critics argue that this practice can foster an environment of distrust and harassment, particularly in marginalized communities. On one hand, we have the duty of officers to protect themselves and the public. On the other, we must consider the rights of individuals to walk freely without unwarranted interference. Is there a way to strike a balance that respects both safety and personal freedom? Terry v. Ohio established what we now know as the stop-and-frisk rule, empowering police to intervene before crimes occur. But this power comes with significant responsibility. As we reflect on this case, we must ask ourselves, are we comfortable with the trade-off between safety and privacy? Is the potential for crime prevention worth the risk of infringing on civil liberties? Join us in the comments below. What are your thoughts on the implications of stop and frisk? Is it a necessary tool for law enforcement, or does it lead to more harm than good? Let's engage in this critical conversation together. Thank you for watching, and don't forget to subscribe for more thought-provoking discussions.